My name is Bethany Servin, and I'm a member of the marketing team here at UsableNet. It looks like we still have quite a few people hopping on right now, and we are only 1 minute past. So we'll just give it another minute or so. Again, we appreciate you joining us today. This webinar is Best Practices and Legal Strategies for Defense of Website Accessibility Lawsuits. It should probably be website and app accessibility lawsuits because we'll be covering both in this presentation, but the title was already pretty long. So I convinced our presenters to let me shorten it a little bit. Like I said, we'll be starting just another minute. We do have a lot to cover. Before we begin, a few housekeeping items. We are recording today's session. A link to access this recording and the slides will be sent in a follow-up email to all registrants. I'm delighted to introduce our presenters today. With us, we have Elizabeth Rodriguez, who is a partner at Fort Harrison in their Miami office, and Jason Taylor, who is the Chief Innovation Strategist and Advisor to the CEO at UsableNet. Please feel free to submit your questions during the presentation. We'll try to get to them either when we receive them or we have set aside time for a Q&A at the end. We welcome your questions and participation, and we'll answer as many as we can. And I do have the option to send any questions that come in that we don't get to the presenters after, and we'll follow up with you. So with that, again, we are recording this webinar. Slides will be made available, and now I'm going to hand the presentation off to our first presenter, Jason Taylor.
Thank you, Bethany. Thanks everybody for joining. Let me take you through the agenda today and sort of just set the scene of what you should expect in the next 45 minutes. And as Bethany says, we'll try to keep 15 minutes for Q&A at the end. Just to give you an idea of the types of people that have registered and are also on listening to this webinar, so we sort of tailored that content. There's a general mix of in-house and ex-house counsel that probably are representing companies that have had some type of legal action. There are quite a few digital team members, so product managers, program managers, and marketing managers that are essentially responsible for websites. There are a few accessibility consultants on this registered for this call and listening. And then there's also a number of people representing web agencies or app developers. So there's quite a broad group. Typically, we try to make this content as general as possible to fit those four groups, and I'll give you an idea of what we're going to cover today. So what I'm going to do is rely on Elizabeth to bring color to the data that we generally track. So at UsableNet, we have a research team that tracks all of the legal cases, federal and state, that are brought against companies around websites and apps. We do that by looking at every single ADA lawsuit, which includes physical, and filtering out the physical from the digital, and then tracking those digital cases. And we tend to report, and today I'll talk generally about the trends that we see, and then Elizabeth's going to back that up with sort of on the ground legal aspects about what's behind those trends, and also practically how to respond or defend some type of legal action. So we're going to start by sort of doing a quick tour of how we got here. So how does the ADA affect websites and apps? We want to guide, talk about how the DOJ over 20 years has sort of set the scene around websites and apps with regard to the ADA. We'll look at the most affected industries. And then we're going to get into some detail where Elizabeth can bring her sort of street knowledge about what to expect to happen after you get a demand letter, or what your options are for responding or defending a legal action. And then we're going to look at briefly sort of what our class is sort of, what you can do right now to mitigate risk, but also increase the accessibility of your sites so you're supporting people in an inclusive way quickly. The sort of solutions that are available to you, and sort of what we would say your sort of roadmap items are for short, medium, and long term when you look at digital accessibility. So maybe I can start first by just getting Elizabeth to take us on a quick tour of the ADA and some of the key cases and DOJ's input around ADA and websites.
Absolutely. Thank you. Thank you, Jason. Well, as most of you have probably heard, the ADA is having its 30th anniversary. So it was enacted in 1990, and it was designed to give regulations with regard to public accommodations. It did not at that time envision the internet or websites or mobile applications, and it didn't apply to these electronic means for many years. The next change to the ADA was in 1998, when the Section 508 was added, and we began to see the application of disability accommodations to government-funded websites and things like that. Then we had the first lawsuit, which was in 2006, and that was the Target lawsuit, and that was the first time that the court was asked whether it applied to websites, and that was in California. Then we saw the ADA amended in 2008, and by then the main issues that we had seen, what's a disabled person, what is a public accommodation, and we started to see the courts find that websites and mobile apps were public accommodations. And then a lot of the litigation since then has also focused on the requirement of the ADA that we have full and equal enjoyment of goods and services by all persons. And that is where we see a lot of the litigation. Is the website offering goods and services? Is it integrated with the physical space? Is there a nexus or a connection to the physical space? And that's a lot of the language that you see in the courts in analyzing it. And then a big push in this area came in 2013, when the courts allowed lawsuits by testers. And that opened it up, because now not only do you have to be a person that is seeking to the services of either the store or the website, but now you're allowed to even say, I'm a tester, I'm an advocate for this group, and I'm bringing this lawsuit because I know the website has been tested and doesn't work. So in that framework is in, and another big area had been in late 2016 and 2017. We had the new election. Everybody had been waiting for DOJ to rule. There, many defenses that had been raised. No regulations. We're waiting for DOJ to rule. And then DOJ said, we are not going to rule. There's going to be a change in focus. We're going to leave that for private enforcement. And so you're not going to, get any. And they stopped intervening in litigation that was going on. For a long time, between 2012 and 2015, they were monitoring the dockets, and any time that a lawsuit was raised and the defense was, a website is not a public accommodation, DOJ was intervening and saying, we don't agree with this, and that's not our position. Since then, I have not seen any intervention by DOJ in any of these cases, and the courts themselves are taking the position that websites are public accommodation. And the big thing was the first trial. It was a bench trial. It was before Judge Scola down here where I live in the Southern District of Florida. And it was the Juan Jill case versus Winn-Dixie. It has made its way through the 11th Circuit Court of Appeals and all the way through oral arguments. The oral arguments were in October of 2019. And now approximately 10 months later, we're waiting for the decision. Judge Scola definitely found the standards in that case. He didn't have to find go as far as to say whether the website itself was a public accommodation, because he found that the use of the website and the store itself were so integrated that it almost worked as a gateway to the store. For example, you could check their hours, you could get coupons to then physically use at the store, you could order groceries and go pick them up. So they didn't address what I would have thought was one of the essential questions, whether a website is a public accommodation, but they went on to then find what the guidelines were, and that was the WCAG 2.0 guidelines had to be applied to the website. And another issue in that case was the use of in-house in order to support the changes that were made. The court had found that the in-house IT would not be deemed an expert because he didn't have only his experience with Winn-Dixie, had to remediate other websites. So that's another interesting issue in these cases. So that
Elizabeth,
that's where we are.
Yeah. Elizabeth, can we go back just one slide? Because I think I want to make sure that we cover the chart on the DOJ and lawsuits, because it just in case people can't see these slides. This is going back just to the sort of the build-up point that Elizabeth talked about in terms of lawsuits which involve the DOJ through, from earlier sort of early 2000s through to 2017, and then the switch from DOJ not being involved in lawsuits to a sort of a far more volume of private lawsuits from private law firms. For those who haven't sort of been following, let's say, web accessibility and lawsuits over the time, this chart actually shows that the DOJ was involved in lawsuits in volume, around 250 lawsuits from 2000 to 2017. As Elizabeth talked about, the importance of that is that DOJ sort of set out what they perceived was public accommodation, websites and apps, and that they entered into settlements with nearly all of these companies for those companies to address the accessibility of their websites, and in some cases apps such as H&R Block. And the WCAG 2.0 AA was sort of the agreed to standards in most of these settlements. So the DOJ sort of set the groundwork, but then sort of left in 2017 some important details that people would have loved to have written down in the ADA, which they never finished, which was, what is the specification? What is the level of conformance which is acceptable? What is the time frame I have to do this? How large a company do I have to be to do this? So because they sort of exited stage left at that point in 2017, they left what I would class as a big void of definition. What are the standards? How quickly do we need to do the standards? How good do we need to do the standards? And how big do we need to be as a company? So it opened up an opportunity for what I class as private law firms and private plaintiffs, who are primarily positioned as advocates, to go after volume of companies. the important thing here is that this isn't something that's appeared in the last 3 years. The DOJ have been advocates of web accessibility and app accessibility for 20 years. Companies have sort of been on notice that they should have been doing web accessibility and app accessibility for a long time. The DOJ has been very clear about what they expect. Companies have, because of the speed of the internet, because of the complexity of the internet, have sort of fallen short on doing that. They've opened themselves up to being sued under not following to detail the WCAG. But also I think it's important, Elizabeth, maybe you could give some clarity on sort of how you see this sort of these types of lawsuits coming together in terms of how they're put together, the fact that they're sort of you know, they're typically filed in batches of 10 or 5 by a particular law firm that works with a particular plaintiff. Maybe you could give us a little background on how these lawsuits generally, and demand letters are generally sort of generated.
They are, and you see by industry, for example, and I think this is also based on the fact that you have a lot of testers that are out there, and they'll give them a topic, for example, automobile, oh my God, dealers, local dealers. So for example, you'll see 10 lawsuits that are filed against different dealers in one geographic area. There was just this week, 40 lawsuits filed against hotels in Western New York. You'll also see different retailers, jewelry. There was recently all the diamond stores, the Jared's, all of them, Hellsberg's Diamonds, all of them were sued in the same jurisdiction and all lawsuits filed. So you see a lot by topic. You also see that, you know, by attorneys, and a lot of the same plaintiffs pop up. And with demand letters, absolutely. Just last week, I got calls from several local real estate companies in Central Florida, and all of them had received demand letters from the same law firm, you know, advising them that their websites violated the Fair Housing Act. So you see novel claims being tossed in a lot of these. Right before, you know, Christmas in New York, there had been 100 lawsuits filed by the same plaintiff with regard to cards and whether they had to have Braille on them. Any of the cards or store cards. So those are how you see them, mainly by industry and retail, restaurants, and anything online sales presence. We've been seeing a large number of lawsuits.
So I'm going to actually just take through like what our class is, the trends that we've seen in the last 6 months, but also the trends that we've seen in the last 12 months, just for people to understand, like, again, how does that equate what Elizabeth talks about in terms of it's realistically, you can talk about it as being an industry. You know, the majority, when I say majority, 60-70% of lawsuits are brought by the top 10 law firms. You know, so there are law firms and plaintiffs which focus very much on generating legal actions, whether that's lawsuits or demand letters. So you know, there's 2 areas that you could potentially be sued: federal court across the country and state. Right now, California state's a very active area because of some state laws there which give plaintiffs some damages where they wouldn't get damages in federal court. But also demand letters are sort of the legal action before going to court. So it's a way for a lawyer to quite cheaply try to engage a company to come up with a settlement before having to file full lawsuits at federal or state level. Typically, they're aimed at commercial websites. You know, many lawsuits, interestingly, maybe I could get Elizabeth to talk about this, are repeat lawsuits, which means that a company is sued more than once So Elizabeth, why can a company be, if they've been sued already and maybe they've even settled with an individual, do they not get an ability not to be sued again? How does that work? Like, why are these companies being sued multiple times?
It is going to depend on jurisdictions. For example, the legal theory of mootness, meaning that a claim is moot and has either been resolved or is no longer at issue, would not apply in Florida, for example, if it is a different plaintiff suing the same company. And that's as a result of the 11th Circuit in a Hooters case finding that mootness doesn't apply for different plaintiffs. Same thing in California, multiple rulings. In the Southern District of New York, we recently had a judge that he himself determined it was moot because he didn't think it was fair that a different plaintiff popped up while the company was making their repairs. So it's going to depend on jurisdictions, and within different jurisdictions, even depending on the judge.
So, I mean, it really does also matter whether you've done the repairs or not done the repairs, right? So that's a big part of the time frame. I think it's important for people to realize that what typically happens, and we've seen this in a practical sense, a legal action typically is handed over to in-house counsel. They go through a negotiation. They end up maybe negotiating with the plaintiffs. They go back to the company and the IT team. They say, "Great, we settled. We've got 2 years to upgrade the site or the app." What the IT team here is, we've got 2 years, so they don't quickly action getting it up and fixing it. But what hasn't been sort of communicated very well is they've only settled with one individual. They have not cleared everybody from suing them. So essentially, if they don't do anything with the website, another individual can clearly come along and sue the next day because the website is as bad as it was when it was sued the first time. Is that correct, Elizabeth?
That is correct.
The other thing that we're seeing is obviously, plaintiffs are, and this is something that Elizabeth talked about, the big areas that we see on a weekly basis. So like last week, there was 72 federal lawsuits. There's about 15 California state lawsuits. About 50% of those are retail-based, primarily because retail is very easy to visit. You can do very similar testing to retail sites. Each one, you can sort of test the checkout, cart, delivery, which is what Elizabeth talks about. Sort of repetitive testing is quite easy to do. And also there's lots of them. They're very easy to visit. But they also have very complicated websites. So they're more than likely not following and not easy to follow the W3CAG guidelines to the letter. So it's easy to find issues on retail sites, maybe less so on smaller, simpler sites. So this is why sort of retail and restaurants are primarily targeted. I'd also say that because they're used to dealing with ADA cases, physical ones, meaning getting into the store, going to the restaurant, the plaintiff lawyers are familiar with how to talk to those companies, and those companies are prepared to talk to plaintiff firms who are issuing ADA legal action because they're used to the process. The other trends that we see are that the W3C has now a new standard 2.1 that's being put a lot into claims, so it's important for people to understand that. And then something that we've seen, in the last 6 months, which is interesting, is there's last year there was a big sort of cropping up of smaller solutions to try to fix this problem called widgets or overlays. We've seen that they don't necessarily help you from getting sued again. So in the last 6 months, at least 100 companies already invested in widgets and overlays have got lawsuits. Because, and we'll get into that detail, but primarily the widgets and overlays don't fix the items that the plaintiffs find and what process the plaintiffs take. And we'll talk about why that is, because essentially there is as Elizabeth said, sort of a set process that they go around looking for on a website. and widgets and overlays don't necessarily fix those issues. So it's easy to still generate a claim based on a site that's using those items. So we talked about this, and I'm going to do this quickly. Mainly consumer facing. Elizabeth talked about the importance of physical and digital locations. That's a legal issue. Some areas of some circuits of the federal court require sort of nexus or connection between physical and digital. Some don't. So that changes in certain areas. As I said, the plaintiffs are looking to get traction. They like to go with companies that are ready to deal with complaints under the ADA. So they also focus on people that already have that sort of capability to sort of respond to stuff like that. So now let's talk about and get Elizabeth to talk about the process and sort of how these things sort of take shape. But just to recap on what Elizabeth said around how does the lawsuit take place? Because I think this is one thing that is very useful for people to understand. What does the plaintiff do? What does the plaintiff firm do to decide your website is not accessible and you're suable? These are the things that you should focus on first to make your site more inclusive and mitigate your risk. So these are the things that the law firms do or their testers do. They test your website against auto-detectable items. They go to your main pages. They see whether there's missing alt tags, forms. They use different types of automated testing, whether that's Wave or other types of testing tools, and they generate a list of issues. They also have, typically, because most lawsuits are brought by a blind individual using a screen reader, they go to the website and try and do the things that you expect a customer to do. If they fail doing that, they document it. They do the same thing for native apps. They basically try to use the native apps and see whether they can or cannot complete tasks. They look to see whether you've got an accessibility statement on your site. What does that statement say? Are you already doing work? Have you hired an expert? Are you making it easy for people to report issues? And then finally, I would say one of the things that you want to do is ensure that customer service knows how to handle inquiries or issues with people with assistive. They know how to escalate an issue with someone who says they've got an accessibility issue. So if you say, hey, how do I start? How do I be proactive? These are the 5 things that you should be focused on today, because they're the 5 things that plaintiffs and plaintiffs firms are focused on. But they also bring accessibility up. They will make your site more accessible. You will understand whether someone with a screen reader can complete the top task. These are very important things for you to know, and they obviously are very important for users. So let's talk, Elizabeth, about what happens when you receive a sort of a demand letter or what's in a claim, and then sort of how to handle that from a sort of a response or a defense.
Absolutely. There's 2 types of demand letters. One will just be the demand, and then another one will have a sample complaint already drafted. Most of these will have violation of the ADA because it's inaccessible. In California, they will most certainly include claims under the State Unruh Act, which entitles the plaintiff to compensatory damages rather than just the injunctive or declaratory relief that is authorized by Title III. Title III does not award damages to the plaintiff, only attorney's fees. And then the Unruh, as I said, in California, that in New York, they'll include the New York State and New York City human rights. And then in Florida, because our state statute or local statutes do not include monetary damages, we've been seeing pretty creative causes of action, such as invasion of privacy. We've been seeing negligence or negligence per se. We've also been seeing claims of violations of civil rights, so then they can say this is disability discrimination, all different ways to try and get damages. And many of the attorneys that do send the demand letter follow up. There's a certain group that send the demand letters, and whether it's because they're overwhelmed and send too many, you never hear back from them. I do recommend, short responses to the demand letters. And one trend we've been seeing is the cases being filed as class actions. Some of them are sloppy and do not have all the allegations. Some of them, particularly filed in Pittsburgh and in California, do have all the class allegations. And I think I can be cynical and say that I think a lot of that is to increase entitlement to fees. Jason had mentioned things you can do initially. I think one very important thing, whether you're just now evaluating your website and everything else, is create a policy. And you can go out there and search them under accessibility, web accessibility policies. There's companies that have gone out there and said, we are in the process of updating our website. And they admit that it's not compliant. We will make it, you're important to us. And then the crucial step is to either put a phone number or an email where if there are issues, they can contact you. And then the next step, which Jason mentioned before, which is also crucial, is then don't leave your poor customer service department without any training as to what to do, because they will get calls. And then the worst thing is to have the policy, the phone number to call, and then not have the follow-up. So it's those 3 steps that I think are important.
Great. I think you covered a little bit of this, but you talked about, like, if you get a demand letter and you say you should sort of probably respond to that. One is, why? Is that because actually there's something that they can do if you don't respond, which is but you want to avoid? And also, let's take 2 scenarios. You're a company that's done a lot in accessibility, and you feel like, well, actually, why am I getting this letter? We've actually done a lot. What would you potentially include in that demand letter in general? I know that is a tough question for a lawyer, to be general. But also, like, on the other side, you're someone that's sort of been caught on the back foot. Oh yeah, we haven't done a lot. What would you say in a demand letter, a response to a demand letter? How would you sort of try to stop this going further? What would be the advice there?
Now I'll give you a very lawyerly answer that a lot of this depends, because, as I said, there's some law firms that I know for the many years of practicing that you get these demand letters and then they do nothing with it. And those I have been known to recommend to my client, let it go. You're never going to, and just work on your website and focus on that and let this, lay here. There is no requirement under the ADA for pre-suit demands or an opportunity. We had seen a trend, and there had been some legislation requiring this, and that's why you had seen the increase in the demand letters. It was their attempt to say, look, I attempted to negotiate and pre-sue, and we exhausted that. Once we haven't seen that requirement imposed, there hasn't been much consequence legally for the failure to respond. But there is in the common law more of, we sent this, they didn't deny it, and you see a lot of that in the litigation. So it's more if there's a litigation, what did you do? Did you receive it? Did you ignore it? Did you take proactive action? All those things. And generally a response that I would recommend is if your website is not compliant, very simple response. The company takes, web accessibility or mobile app accessibility very serious. We're in the process of having, our marketing and IT departments invest substantial time and money into improving it. We don't have, a timeline. So something very, very general like that. If they have been sued before, I have been known to redact the confidential portions of a settlement and respond saying, this was brought up before, we were involved in litigation and resolved it, and we have until this date to, and in some cases, I have convinced opposing counsel to not pursue it in light of that settlement. Others responded, the law allows us, and this is a different complaint. So many different scenarios that can pop up.
Yeah, I'd actually like to, give that some color in terms of our experience, right? So our first recommendation to any prospect or anybody who says, we're responding, we got a demand letter or we got a law, what should we do? We would typically say the first thing you want to do is talk to an experienced external counsel around that letter or lawsuit to leverage their knowledge, firstly, of who's bringing the suit. Because as I said, it's very, this is a very focused world. So as Elizabeth said, she knows, she can read a demand letter and see who it's from and roughly know what their playbook is, like what is their next move because of experience, what has worked before because of experience. And this is why it's important, I think, to leverage some of the experienced sort of ADA defense lawyers, because they know what the plaintiff firm is looking to do and achieve. And they also know whether, it's going to be useful to respond or not respond. It's going to be, what should the response be to try to get them to put you further down the sort of chase list, because what you say back is sort of like the stuff that they don't like to hear, as opposed to the stuff they do like to hear, right? So this is why sort of engaging counsel early, just to review the types of legal action you've got, because they can bring a lot of sort of what I class as experience, which might be cut and paste, because the whole sort of nature of a lot of these lawsuits are cut and paste. So they know what's going to happen next. They know what the actual sort of goal is of a particular plaintiff or plaintiff lawyer. So if we could just move on to the next, because I think we're getting close to the sort of 40-minute mark, and I just wanted to cover two subjects. Bethany, if you can move to the next slide. So I just wanted to cover, because I think it's very important that nowadays there's a range of solutions out there. There's many companies that offer support to companies that want to bring accessibility into their sort of process, into their websites and apps. And I think it's important to understand that there's typically, there's sort of a grouping around three particular approaches. One, our class is sort of integrating accessibility. So that's hey, actually, yeah, this is something that we want to make sure that when we produce a website or an app, it's accessible. We don't want to get lawsuits. We want to support everybody. We see the value of accessibility from supporting the disability community, making them our clients. And we want to go ahead and sort of bring that knowledge and integration into the way that we do work. So, that's typically the way that we would recommend to clients, that they should integrate accessibility into their websites and apps. So the experience is the same for everybody. There isn't a different experience for one over the other. Most people who have disabilities use assistive technology. If the website is coded correctly, they have no issues whatsoever. So if you want a sort of long-term solution where every time you build a new website, every time you do an update, every time you launch a new digital experience, your team is sort of up and running, sort of knows about it, where accessibility, has had training, you might want to look at vendors that provide you sort of the ability to integrate accessibility into what you do, bring some knowledge in-house, help with training, help with products that your teams can use to build accessibility into everything they do. Then there's two other groups that are reasonably new. One is what we class as overlays. So this is a combo. It's a little bit like, hey, there's lots of low-hanging issues like missing alt tags. And actually, we could probably inject a sort of fix quickly for those. But there's more complicated stuff like hard to use navigation, maybe dynamic components of things like drop-down menus and add to cart. And those are harder to fix, and they provide sort of an alternative workaround with widgets to do that. The limitation here is most current assistive technology users don't particularly like these solutions. They don't have a lot of support. There's a little bit of unclarity on the legal side. These are not solutions that are agreed to in settlement letters on the most part. And I would say that they're good for simple sites, but they're not going to work for a dynamic sort of site that's got a lot of functionality. And then the final group, which has come around really on the back of lawsuits, is a quick fix. Add a button to a website that says you're doing something, but really it doesn't fix anything on the original code. It just provides a bunch of features that look good on first inspection, but then when you actually talk to people who you're trying to help, assistive users, they will avoid these types of solutions. And there's quite a bit of a disdain out there around people putting these types of widgets on to solve accessibility, because from a user perspective, they're very inadequate on improving a website. And maybe Elizabeth, you could talk to you about your experience of companies that have sort of chosen to use a widget or an overlay over sort of integrating accessibility, as I sort of covered in the first part.
Well, we're seeing that a lot of the widgets and the companies providing them are now being included in lawsuits. So we're waiting. There's several that are working their way in California that everybody's watching with some of these widgets. So you have to be very, very careful.
Yeah, I mean, at its fundamental level, there's a sort of, if you can do it the right way, do it the right way. The other issue with widgets is you're adding more functionality that could potentially mean that another group of people with disabilities can't use it, and you can be, opening yourselves up for adding technology to your site which helps some but not others. And again, that is, that's opening yourself up for a discrimination lawsuit again. So, there is a clear, well-documented 20 years of this is what you should do. And actually it's doable. It takes some time, it takes some resources, but the end result is a fully inclusive world. Everybody can use a website and app in exactly the same way. So sort of to recap, short-term, medium, long-term, most people are sat on this call thinking, okay, what can I do short-term? That's really the recap that I gave about being proactive. It's, do what plaintiffs do, because it will improve the accessibility of your site. You'll get direct feedback from people who use assistive technology to tell you whether your site's good or bad. That will help you get support internally to do things. Make sure that the things that are easy to find have been fixed, and make sure that you've had this conversation. That there's another reason why I believe in statements and policies, particularly because your company's not going to let you put a statement up on the website unless it's been discussed about what is the structure, how are we going to actually deliver this statement. We can't just make a statement. We need to do what the statement says, what resources we're going to need. A lot of people might be the internal advocate for getting accessibility done on the website, but they're going to need resources. They're going to need buy-in. So, getting a company to understand the value of a statement is not just the public declaration of a statement, but also the internal support for that detail, and making sure that people know that it's important, and you can get developers to do what you want them to do from an accessibility perspective. And then medium and long term, lots of documentation out there. Essentially, you need, this needs to become part of what your teams do. It's something that's doable. It's something that's trainable. There's lots of tools out there to help you do it. There's lots of documentation about the help to do it. In my experience, if you show developers and tech teams there's a problem, and you help document that problem, whether you're using user testers or you're using tools to show them where the problems are, they get challenged and they want to find solutions, and they're totally capable of making sure that their websites and apps are accessible if they know that it's important to the company, and they're going to be, that they're going to get kudos for doing that. They will come to the table and they will rise to the challenge, and they will make sure that their websites and apps are accessible. Elizabeth, before we go to Q&A, is there anything you wanted to sort of add on the back of that?
One other word of advice, and we hadn't covered it in the slides, but I've had it come up in the last 2 weeks, is if you are using third-party vendors, whether to use as a template for your mobile apps or even for your website, or if you're a hotel and you're using a third-party vendor template for reservations, please check the agreement that you have with what that vendor is supposed to provide with regard to accessibility. Because as the owner of the website and the owner of the business, you're ultimately responsible. And it's not a defense that says, I don't control my website, because it's your responsibility. You're holding yourself out as that being your website, and you're going to end up either having to change vendors if you're not properly covered, or have a very difficult conversation with that vendor. But the law hasn't made it where I could just argue, hey, we don't provide the content for the website. Same thing as when you're a landlord and your tenant makes any changes to the physical property that's no longer accessible, you are responsible. And they've extended that principle to websites. So read those agreements, make sure you're protected and have the right indemnity and liability protection.
Yeah, I would say this is probably one of the most important points, especially in the new digital world. Most companies out there have paid someone to do something around their website or app, whether build it in the first place, maintain it. As Elizabeth said, maybe if you're a smaller company, you're using templates. But big companies are paying, large amounts of money for companies to build digital websites and digital apps for them. It's very important that the requirements for accessibility are built into those contracts. I've actually written a couple of blogs on how you could add in these types of clauses into a website agreement. There's actually legal cases in California right now where a website vendor that built a website is being sued by the California state for not producing an accessible website, even though that it was part of the contract. So very important to push the responsibility where the money's being spent. So I talk about, if you're paying for something, make sure that it says that it needs to be accessible to a particular standard, and there's recourse and there's verification, because not just a tick box that people tick and say, yeah, they're accessible, don't worry, because if you get sued, you're going to be the one paying for the lawsuit.
Okay, thank you guys. We are getting a lot of questions, so I would like to start going into them. This is Bethany speaking. Can I just go ahead and start reading some to you, Jason and Elizabeth?
Yeah,
Sure.
I just also want to make sure that everyone knows that if we don't get through all the questions, Elizabeth and I will review the questions afterwards and make sure we respond to any that we didn't get to. So don't hesitate to sort of keep adding questions if you feel like, oh, they're going to run out of time. I'm not going to ask something. Please ask, and we'll make sure that we get back to you.
Do we have any set of protections or certifications that can be used as a defense layer if facing or when facing legal lawsuit? Protections or certifications that they can use?
Well, one of them, I mean, you do see one of them would be an agreement in which your vendor, if they're doing your website, provides that it is. And you see some companies that give you a certification once they've done your website that you can put on there. I've seen them. But I think the biggest one would be make your website compliant, make sure that the vendor has done that to the WCAG 2.0 AA standard, which is what the cases are imposing, and then make sure you have the indemnity for that.
Yeah, just talk, Bethany, just from a user perspective on that. When we work with companies that hire us to help them sort of set up their accessibility plan and integrate accessibility, we have a certification program that we support them with. So essentially, we track that they are doing the, I think we have 5 core components that we track. If a company is doing that, we give them the ability to use us as reference, as a certification that they're doing all the right things, and we support them, with things like annual documentations of ongoing activity and support for accessibility. So there are things that you can make sure that you sort of bolstered your sort of documentation and make sure that you're communicating these are the strong activities we're doing. And if you are doing them, we don't see companies that if they're really set up well, doing accessibility well, documenting it, communicating it, they are not receiving lawsuits, because essentially lawyers are looking for easy wins, not hard wins.
Okay, so I have 2 related questions. Would you suggest publishing an accessibility statement even if you haven't started or completed changes proactively? And then the second question is, how much protection is offered by an accessibility statement? And they have an example of one.
Elizabeth, you want to take that?
I have recommended it to some clients. This one in particular was a venue that offered large events, and the season was just starting when they received the demand. So in the expectation that a lot of people may encounter issues, I did recommend, and they did post a statement that they were in the process of revamping their website. I had another client that had a lot of issues with their old website, had patched it up, and then said, we're just going to start from scratch. And they posted that on it. The protection is more in order to, the ADA requires full and equal enjoyment of goods, and that you're not discriminating on the basis of a disability. And so I think those are all valid defenses. We have a policy in place. We've, have no intent to discriminate. We're in the process of doing this. So those are all legal defenses that you can use.
And I would just add, I would very much encourage you add a statement if what you write in the statement you are actively doing. I would disencourage you to write a statement which is for the sake of the statement. If you are actively doing the items that you put in the statement, then you will be reducing your risk, because if you are testing and fixing for W3AC, if you are testing with people with disabilities, I would disencourage people trying to say we are already 2.0 AA compliant. You need to be talking about what are the activities and efforts that you are doing, and make sure that you are doing them. those statements are very useful, very powerful, and also for the disability community themselves. They warm to brands that are trying to support them and make it easy for them to communicate with that brand if they are having an issue. And as Elizabeth said, making sure that that statement includes an easy and trained group of people that, if someone rings up and says, I'm having an issue, I'm using a screen reader, they know what to do with that. They don't have to fix it, but customer support need to know that that's a question, that's an issue that might come up. How do I escalate that? How do we keep communication with that person so that doesn't become a source of a potential lawsuit?
So we have a question a little bit related to customers having customer support kind of supplement with the website. If you are a very small business, is there an undue burden threshold? And then they say that customers can always call customer service to walk people through all the items on the website, describe the products, read reviews, etc. Like, is that enough?
Let me answer. There is an undue burden. In fact, it was one of the defenses that Winn-Dixie had raised in its lawsuit. And what it went back to is the judge actually looked at how much Winn-Dixie had spent on the creation of its website, which when they added it up in that particular case, they had spent approximately $250,000 with their new website and how it was done. And then they had the plaintiff's expert testify as to the cost of compliance, which would have been $56,000. So yes, it is, but if you raise it, make sure you can have the numbers to back it up. And with a small company, I understand, it may be easier, but as with the physical, it's a difficult burden.
Yeah, I'd also add, Elizabeth, and maybe you talked to this, unfortunately, it goes back to the fact that the ADA has no clarification of what is accommodation, a reasonable accommodation, what is allowed to be seen as reasonable accommodation with regard to websites and apps. I think that, what was described, small business, you can call us anytime, whenever open, that sounds reasonable. It sounds absolutely reasonable as a way that you would probably defend, you'd probably explain to an individual that's trying to get real service. But unfortunately, lawsuits aren't genuine people that are in many cases, trying to use your website. They're looking for a reason to generate a lawsuit. So again, they do the things that I explained. And actually, if you've got a small website, you can probably cover most of that quite quickly and make sure that you're not producing any easy to find issues on, missing alt tags and labels on forms. You have documented that you've had an assistive user try the site and make sure it works well. You've created a statement. That's gonna protect you a lot better than waiting for a lawsuit and then hiring someone like Elizabeth to defend you based on sort of a process, which I think is a fair process, but at the end, it's going to cost you money to try to argue that is a fair process. That's my sort of take on that.
And let me add, because I just scrolled through some of the questions on two things that I actually meant to bring up before. Some people say, why am I being sued by a plaintiff in Florida? And you're not going to be able to say we're not going to sell in certain states to avoid liability, because the plaintiff could be anywhere when they sue you. And we have had courts rule that, the internet can be accessed from anywhere. And as long as, your website is up and running, it doesn't matter that you're not selling in that state. So you're exposing yourself to that. And then another one I have heard is, we don't have, brick and mortar stores. That'll work in some jurisdictions. But for example, in New York and in California, they've allowed website only businesses to be sued. And they've determined it doesn't matter that's all you're doing, selling, on the internet. that's sufficient. So as I said, it's, and the plaintiffs are smart enough. They'll go to the jurisdictions where there's favorable case law.
Yeah, and I sort of just add this: if someone comes to it comes, and it goes back to what Elizabeth talked about in terms of undue burden. Our experience is that, you know, even if you didn't do any web accessibility work on your website or app, and you need to make it accessible, it's probably going to cost you somewhere between 10 and 20% of the original cost to add accessibility. So obviously, the smaller and simpler your website, the cost of implementing accessibility is going to be smaller. If you've got a very complicated website you spend $1 million on, it's going to probably cost you $100,000 to $200,000 to make it accessible. But the alternative is paying lawyers to defend you. So, you know, and actually the smaller you get as a company, probably the quicker and cheaper you can make sure that you're doing what I class as the proactive steps without spending a lot of money. And that will be a lot cheaper than sort of waiting for a demand letter and then needing to call a lawyer to find out what to do with a demand letter. That's my general impression in terms of what people should be thinking about.
Okay, so we are 1 minute past. I want to thank everyone who joined us today. And again, for anyone that joined late or missed it, we did record this webinar. You will get an email in a couple of days. We'll have a link that you can click in to watch that recording. There'll also be a link where you can download the slides as a PDF. And I guess before we conclude, Jason, Elizabeth, did you have any final thoughts that you wanted to share?
No, I just want to reiterate that if we didn't get to your question, we'll make sure to respond to your question by email, because I do appreciate when people ask questions and make sure that we've covered the subjects that you need to cover. And
by all means, send me any questions you may have, or if you thought about it later. This is an area, obviously, as you could hear, that I'm actively involved in, and I'm always eager to learn and interact with, you know, people as to issues they may be encountering.
Great. Okay. So thank you everyone for joining today. Thank you, Jason and Elizabeth, for sharing your expertise. Again, there'll be a follow-up email, and then as part of that email, someone did ask the question. Yes, we can include some links to those blogs that were mentioned too, so you have some additional reading on the topics that we've covered. So we appreciate your time, and with that, the webinar is now ended.
Thank you.